This is the third day of hearings today, Jess. What was the topic of conversation?
Well, there were two topics. In the morning, the court addressed the possibility that if the individual mandate to carry health insurance is struck down, how much, if any, of the rest of the law has to fall as well. In the afternoon, the court heard argument over whether the Medicaid expansion is itself constitutional or whether, as 26 states led by Republican governors contend, unconstitutionally coerces the states to support a program that they don't want to.
Jess, it seemed like the tone from reports on the exchanges in the court was a little more bombastic, a bit more caustic than we saw previously. Obviously, that's sort of par for the course for this court, but it seemed the sentiment was moving that, hey, this thing just might not survive.
Well, that's true. This was, of course, the third day, and it's as if the suspense and drama built with each day. I mean, the Supreme Court is not a place where you see flamboyant rhetoric like you might in Congress across the street. But by this day, the weight of these discussions and the realization that at least half the court, and perhaps most of the court, has great skepticism about many of the things that have been taken for granted for decades about the relationship between the federal government and the states. This was a court that seemed certainly open to reconsidering some of the doctrines that have held sway almost since the New Deal. The interest in these topics, I mean, the court originally scheduled 5.5 hours of argument. It later extended it to 6 hours of the government's request. The court went an extra half hour today just because the justices had so much to ask and the advocates had so much to say in response.
What seemed to be the most contentious issues?
Well, the healthcare law is 2,000 pages long, and it includes not only the thing that we've mainly talked about, the requirement that most people carry health insurance, but many, many other provisions, most of which are unrelated but have something to do with health, whether they are the black lung disease treatment program or health subsidies for American Indian reservations, or a requirement that restaurants include calorie counts on their menus. And the question is, how many of those things also stand, excuse me, or also fall if the individual mandate falls? And the inclination from at least the questions the justices were asking seemed to be that they don't want to get into the situation of reviewing each provision and seeing which is related enough to the individual mandate and which one is not, and might just throw out the entire thing and let Congress start from scratch. Now, the government had a different view. They do agree that if the individual mandate goes, two related provisions, one requiring insurers to cover anyone who shows up and one barring rejections for pre-existing conditions, that those would have to go also because they would not be financially viable without universal or near universal participation in the risk pool. But they say the rest of the law, including the creation of state-based health exchanges, some of the subsidies for people who can't afford insurance and so forth, the rest of it should stand because it is not subject to constitutional challenge. That the most respectful thing to do would be to let those stand, and if Congress doesn't like that, they can always amend it. The court did not seem persuaded of that argument. I think it's too close and too soon to say the court was taken with the opposite view, however, that the entire law should go. If it does, I don't think we can call it a surprise.
Okay, stay with us, Jess. We want to hear from Chief Justice Roberts today from the hearings.
Is he joining the Hub?
The reality of the passage, I mean, this was a piece of legislation which had to be a concerted effort to gather enough votes so that it could be passed. And I suspect with a lot of these miscellaneous provisions that Justice Breyer was talking about, that was the price of a vote. Put in the Indian health care provision and I will vote for the other 2,700 pages. Put in the black lung provision and I'll go along with it. That's why many of these provisions, I think, were put in, not because they were unobjectionable. So presumably what Congress would have done is they wouldn't have been able to cobble together the votes to get it through.
Now, that was Chief Justice Roberts talking about basically the way the sausage was made. Jess Bravin, talking about the way the sausage was made, is that really that relevant to this case? And explain how, if it is, how.
Well, in many bills, there is a section that says Congress's preference that if some of the measure is struck down, then the rest of it will remain intact. This bill does not have a provision that says one way or the other what Congress would prefer the court do if it found one provision or another unconstitutional. So then in that situation, the court has to look to certain objective factors to decide how to approach a piece of legislation. Usually, they don't do things like try to psychoanalyze the legislative process, as you heard the Chief Justice doing there. Usually, they look to structural elements of the bill, and they try to look at what can stand by itself and what cannot. So, but I think today we saw a lot more of a kind of analysis of what the legislative branches do across the street, and it certainly didn't seem like the members of the court had a lot of regard for it.
Thank you very much, Jess. We're going to now hear from Justice Ruth Bader Ginsburg. She represents the left wing of the court. She's addressing Paul Clement, the challenger's lawyer.
Mr. Clement, there are so many things in this act that are unquestionably okay. I think you would concede that reauthorizing, what is it, the Indian Health Care Improvement Act, changes to the black lung benefits. Why make Congress redo those? I mean, it's a question of whether we say everything you did is no good, now I start from scratch, or to say, yeah, there are many things in here that have nothing to do, frankly, with the affordable health care, and there are some that we think it's better to let Congress to decide whether it wants them in or out. So why shouldn't we say it's a choice between a wrecking operation, which is what you are requesting, or a salvage job? And the more conservative approach would be salvage rather than throwing out everything.
Ruth Bader Ginsburg saying salvage versus wrecking. Dennis, you were itching to jump in.
Well, I was. One voice we're not hearing in here is Justice Kennedy. Jess, tell us whether Justice Kennedy spoke up and how you perceived his comments, because he, as in so many of these cases, is an important vote.
That's right. Well, Justice Kennedy, and again, we're still talking about the morning session involving what the lawyers call severability of sections of this law. Justice Kennedy, by his questions, seemed to find it less problematic to just strike down the entire law, assuming that any part of it has to go, than to try to parse the document for what can stand and what might not. That was definitely the leanings of his questions. The caution that we have to say for those who watch the court frequently is that while some justices telegraph their ultimate positions quite clearly through these argument sessions, Justice Scalia perhaps more than anyone, Justice Kennedy's questions tend to seem to reflect what he's actually puzzling over and pondering, and sometimes he may reach different conclusions. So I don't think we can call his vote the way we might some other members of the court, but his questions all seem to be aimed at the government, all seem to be sympathetic toward the view that the cleanest thing that the court could do, should it strike down the insurance mandate, is to get rid of the entire bill and let Congress, should it choose to re-examine health care, start again.